let's talk about just the foundation of the structure of government, and then we'll get into the judicial branch. I assume everyone knows we have three branches of government in Florida: executive, judicial, and legislative branch. We have a very strong separation of powers doctrine. The court interprets it very strictly. A few examples to illustrate what that separation of powers doctrine means might help get us started. So the Florida courts may not exercise policymaking or appropriations functions that have been delegated to the legislature by the Florida Constitution. The courts may not interject themselves into political disputes that have been resolved by the legislature or that would immerse the courts in policy decisions they are ill-equipped to resolve. The courts may not interfere with day-to-day operations of the executive branch and decision-making within the executive branch. Likewise, the legislature may not formulate rules of procedure or regulate matters related to the administration of the courts, nor may the legislature limit the constitutionally assigned jurisdiction of the courts. Alexander Hamilton addressed the role of the judiciary in Federalist Number 78. So I want to read you a quote to sort of give you a feel for what the founders' ideas of the judicial branch were. The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. So that sort of expresses the view of the separation of powers provision in the Florida Constitution as well. So let's move from that big broad brush overview to the actual court system in Florida. Article 5 of the Constitution of Florida establishes the state court system in which is vested all the judicial power in the state. Before 72, Florida had a patchwork system of courts that differed greatly from county to county and was under no central authority. In 1972, the voters adopted a revision to Article 5 and created our unified court system, which still exists today. The court system consists of trial courts, the county courts and the circuit courts, and then appellate courts, the district courts of appeal and the Florida Supreme Court. No other courts can be established by the legislature or by any other body. The 72 revision placed the entire state court system under the administrative control of the Chief Justice of the Florida Supreme Court. Through the Chief Justices of the lower courts retain substantial discretion in administering their own courts. In 1998, voters approved another revision requiring the state to fund most of the court system, although some functions are still funded by the local governments, including security, construction, and maintenance of local courthouses. All appellate court costs and expenses are paid by the legislature. So in terms of who can serve as a judge or a justice, a person is not eligible, not this one, not that one. That one's mine, it probably has doodles all over it. Oops. A person is not eligible to serve as a justice or a judge unless that person is an elector of the state and resides within the jurisdiction of the court on which they wish to serve. A judge or justice may not serve beyond the age of 70, except if the justice or judge reaches 70 during the second half of the 6-year term, they may continue to serve in office until the term is completed. To become eligible to be a justice or a DCA judge, one must have been a member of the Florida Bar for at least 10 years. To be eligible for circuit court judge, one must have been a member of the Florida Bar for at least 5 years. A county court judge must be a member of the Florida Bar. Justices of the Supreme Court and DCA judges are first appointed by the governor, who must select from a list of 3 to 6 names submitted by a Judicial Nominating Commission. After appointment by the governor, each justice or judge must stand for a merit retention vote. in the next general election that is more than 1 year after the date of appointment. Voters have the opportunity only to say yes or no as to whether the justice or judge will be retained in office. If they say no, the governor will appoint a replacement from a new list submitted by the nominating commission. To date, in Florida, no justice or judge has been removed by the voters during a merit retention election. After merit retention, each justice or judge serves a 6-year term, and then after that 6-year term expires, they are again on the ballot for merit retention. Florida does not have term limits for our justices and judges. It has been considered by the legislature, but did not pass. And actually, we're not aware of any other state, right?
No, we're not.
Yeah, that has term limits.
For Supreme Court justices.
And DCA judges, or any of the judges, actually. None of the judges have a term
None
limit.
of the 50 states have this.
Correct.
There was an obscure one in I believe Nevada where the probate judges are term limited, but that was it. Anyway.
Yes, ma'am.
You said none of the other states have term limits, but we have a retention system, though no judge has ever been voted
Correct.
out. Do other states have a different type of retention system? Do you know? And do you know how that compares?
I don't know the number of states that have it, but there are other states that have similar merit retention systems applicable to their appellate jurists, judges, and justices. Very few have ever been put out on a merit retention, but
Okay.
it has happened in other states.
In those other states, is it very similar where you're only, where you're not retained if you get enough votes? So to say over is it 60% threshold?
Oh,
or
I would
50?
have to look at Florida's a
threshold?
50%,
50, right.
and I believe all the other states are also 50, but again, I'd have to look that up for you.
Do you mind looking that up to see
not at all.
comparatively the other states, their retention system, how that works, and based on that and how long it's been in place, if other judges have not been retained?
That might take a little time. Just to let you know. Okay.
So just real quickly, and I'm definitely not an expert on that, but I know several other states have affirmative elections, even for their Supreme Court justices. And I think Wisconsin and Texas and some of the others have not just retention elections because they don't really necessarily work, as you've never had one removed, but they have kind of these affirmative elections. And then some of them also require people to disclose their kind of political views, so you can't like hide under the cover and say they require you to be fully disclosed.
So are they partisan? I'm sorry.
But yeah, they require you, like Texas requires you to disclose what your party registered. It doesn't let you hide it.
Okay.
Interesting.
Yeah.
Is that for all levels or just Supreme in Texas?
I think it's all levels. Yeah.
Interesting.
Yeah.
So then they have, is it okay?
Oh, absolutely. You guys feel free to talk amongst yourselves.
So then in that, it's just a normal election process,
Right.
not a retention.
Right.
Okay, so in that, can you note which states just have a normal election process where they're judges? Because in essence, I feel like,
I think we're one of the few states that's a majority
Okay.
appointed.
okay, so I guess what I'm figuring out is though these other states perhaps don't have term limits, they have an election process, not a retention process, which is a huge difference.
And I should correct myself because county and circuit court judges are not subject to retention. They're elected.
There are certain
Right.
county judges
Yeah.
are elected, yes.
So the retention applies to DCA judges and Florida Supreme Court justices.
I was also curious, how many folks serve on the Judicial Nominating Committee and how are they appointed?
Mine works now.
Oh, okay.
Judicial Nominating Commissions, there's, 26 of them in the state. There's one for each of the judicial circuits, 5 for the 5 DCAs, and then 1 for the Florida Supreme Court. Each of them has 9 members. Those 9 members are all appointed by the governor, although 4 of the 9 are appointed from a suggested list provided by the Florida Bar.
Okay.
And we can get you that statute.
Thank you.
I'll defer to you if you want to go. Sure. So I'm a non-lawyer, very interested in this area though, and I've heard that the Florida Bar talked about several times. That is a private, non-governmental entity, correct?
I would say it was a quasi,
They are a quasi-governmental
Governmental,
entity. They, in one sense, are private in that they have their own budget. They're not on state budget. They're not state employees that are part of the FRS or any of that sort. On the other hand, case law holds that the sovereign immunity applies to actions of the Florida Bar. And the Supreme Court has also ruled that they are a state entity for purposes of property tax. So the Florida Bar Building does not have to pay Leon County a property tax.
There's zero accountability with the voters, right? They are privately held. Voters can't hold them accountable for any of their decisions, actions, or inactions.
The voters have no,
Right.
the voters in general have no control over the Florida Bar.
and because the Florida Supreme Court has absolute authority to regulate the activities of lawyers, the Supreme Court is the one that has to be accountable for the actions of the Florida Bar.
You can't even get there unless this private group of individuals with no accountability to the voters has blessed you.
Get there in terms of if you're an applicant who is denied.
Your qualifications you were mentioning before, you've got to be a member of the bar for such a certain amount of
Yes,
time and things like
yes.
that, unless they've said,
Right.
and that's a constitutional thing, not a statute thing that's given them this authority.
I think it's statutory, isn't it?
The exclusive admission of attorneys to the bar is constitutional.
Right, but the 5-10 year, the
The 5 or 10 years
eligibility.
is also constitutional.
Oh, it is?
Yes, the 10-year eligibility is constitutional.
So we can't, well, joint resolution. And so I should stop right now to make a big point of introducing Chair Chris Sprouse. He's dropping in to say hello, so I hope he knows all of this that I'm talking about already, right? Oh, good. Okay, should we move on?
Representative Sullivan.
Oh, okay,
Sorry.
no problem.
In regards to the Judicial Nominating Committee that you were referencing, do you know if all other states have that same process, or if some states, the governor gets to directly choose? Because the Judicial Nominating narrows it down to 3 people, and it's my understanding that then the governor chooses from those 3. Is that correct?
It's 3 to 6.
3 to 6.
Okay. Do you know if there's other states where there's not a judiciary nominating committee where the governor just gets to select?
I don't know the numbers.
Okay.
I believe the majority of states do not have a judicial nominating commission process in place.
Okay.
And Florida was kind of the leader in getting that started.
Okay. When you get the other information, do you mind breaking that down for me?
Can I follow up with the JNC question? And I'd like the same things that Representative Sullivan had asked for. The makeup of the JNC, Judicial Nominating Commission, how is that made up?
There are 9 members of every judicial nominating commission. The 9 are selected by the governor, and they serve 4-year terms each. And there's a staggered terms process for those members. 4 of the 9 are nominated from a list provided by the Florida Bar, suggested. Now, the governor has the right to reject all names on the list and ask for a new list, or the governor can appoint from the list given to him or her by the bar. The other 5 nominees are solely at the discretion, or 5 members of each judicial nominating commission are solely at the discretion of the governor.
Thanks.
All right. So let's talk about appointment and election of trial judges now. So we've moved on from DCA and Florida Supreme Court judges down to the trial judges. Trial judges stand for election in nonpartisan races every 6 years. If a vacancy occurs before a judge's term expires, the governor appoints a replacement in a similar manner to the way the governor appoints DCA and Supreme Court justices through the JNC process. A candidate for judicial office, even if not a sitting judge, are bound by special ethical rules. All justices and judges must devote themselves full-time to their judicial duties. They cannot practice law or hold any office in a political party. The Judicial Qualifications Commission is independent of the courts and polices judicial conduct and has authority to recommend discipline for misconduct ranging from public reprimand to removal from office. The Florida Supreme Court, however, has final say in that. If a Supreme Court justice is charged, the other justices are automatically removed and senior justices from the other courts sit in judgment. This is something that all of you as House members should be familiar with. The House is authorized by Article 3, Section 17 to impeach any judge. Florida Supreme Court justices, DCA judges, and lower court judges. And they're liable for impeachment for a misdemeanor in office, which is not defined in the Constitution. So what that means is the legislature would define that term in House rules, or their rules, House and Senate rules. No, House rules. The House would define that term because the Senate tries impeachments, but the House actually conducts the impeachments. The House, by a 2/3 vote, has the power to impeach a judge or any other officer that the Constitution authorizes us to impeach, or you to impeach. The Speaker has the power at any time to appoint a committee to investigate charges against any officer who's subject to impeachment, including any judge. A judge impeached by the House is disqualified from performing any official duties until acquitted by the Senate, and unless impeached, the governor may by appointment fill a vacancy in office until completion of the trial. So the House rules have a new provision regarding impeachments, and so if you're interested in that area, you might want to check out the rules, and Don Rubottom, the staff director of the Public Integrity Committee, would probably be the best person to help answer any questions.
Can define the terms in the rules of the impeachment. What terms to be defined?
Misdemeanor in office. So public officials are subject to impeachment for misdemeanor in office, but the Constitution doesn't define misdemeanor in office. So it would be up to the House to determine what that term actually applies to.
I was just curious because a misdemeanor doesn't sound like an objective term.
It is not the same
objective
thing
term.
as like a criminal misdemeanor. It's a much more general word in this context. So it's not a crime. It doesn't have to amount to a crime at all. So to the trial courts. County courts the Constitution requires the establishment of a county court in all 67 counties. The number of judges in each county varies depending on the caseload and the number that's recommended by the Florida Supreme Court and approved by the legislature. To be eligible for office as a county judge, the person must be an elector of the county and a member of the Florida Bar for 5 years. In counties with a population of less than 40,000, the person just has to be a member of the bar. So, in terms of jurisdictions of the various levels, the first page describes the jurisdiction of each of the courts. So I'm not going to go through each of these unless you guys have questions.
I have a question.
Okay, good.
When was the last time the jurisdictional, I don't even know if it's on, so I'll speak loudly. When was the last time the jurisdictional limits were adjusted, like for county, small claims from 2,500 to 5,000 occurred several years ago, but
I don't remember the year. I believe it was in the 1990s.
I don't remember. Want us to get back with you?
yeah, that's something that would be within our purview though, right?
Yes, sir.
Yes.
Okay.
Talking about the current $5,000 limit between circuit and county?
Right, and then
Yes,
15.
that would, yes, that's within your purview.
Okay.
So I assume you, well, I won't put you on the spot.
So public utility cases, that's original jurisdiction in the Supreme Court? Are those rate cases that we're talking about, or are those something different?
Representative White's referring to the blue box on the top left-hand corner of the sheet you're showing, where it says constitutional questions, capital cases, public utility cases.
Yeah, it's just PSD rulings on any of their electric, gas, or telephone rate cases.
Okay,
So yes.
got it.
My follow-up to that would be my understanding is the PSC is an arm of the legislature, though, not executive or judicial, but
But I think in their capacity as a quasi judicial body, when they're sitting as I don't remember. I used to represent clients over there, but I don't remember how it worked. But I think that even though they're an arm of the legislature, when they're ruling on public utility cases, it's treated differently. So the majority of non-jury trials in Florida take place before one judge sitting as the county court judge. They're referred to the people's court, what?
Circuit or county.
Circuit or county, well,
Yes.
my notes have county court judge, Nathan. The county courts handle voluminous citizen disputes such as traffic expenses, less serious criminal matters like misdemeanors, and relatively small monetary disputes. The legislature sets salaries for all of the judges, and salaries for county judges is $138,000 per year. So circuit courts, there are 20 circuits, judicial circuits in Florida. And the map is on the second page, and you can see all of the counties within each circuit. The number of judges within each circuit has to be approved by the legislature after recommendation by the Supreme Court. And the number of judges depends on the caseload in the area. Circuit judges are paid $146,000 a year, as set out in the GAA. And their circuit court jurisdiction is also on the first page of the chart. There are 5 district court of appeals in Florida, and the number of judges is set by law. There's a map of the districts on the third page, so you can figure out who is where. A panel of 3 judges considers each case, and 2 judges must concur in order to render a decision. And again, the DCA jurisdiction is in the orange box. DCA judges are paid $154,000 a year. There are 7 justices of the Florida Supreme Court. 5 justices are necessary for a quorum, and it takes 4 justices to concur in any decision that the court issues. So they can't take any action unless at least 4 members agree to a decision and at least 5 members participate. So the Supreme Court has mandatory and discretionary review of various issues. Their Supreme Court must hear appeals from final judgments of trial courts imposing the death penalty and from orders of the trial court in bond validation proceedings. They must hear DCA decisions declaring a statute invalid or a provision of the state constitution, and they must hear PSC rulings on electric, gas, or telephone rates or service. They have discretionary review over any decision of a DCA that expressly affects a class of state officials, expressly declares a state statute valid, expressly construes a provision of the state or federal constitution, expressly and directly conflicts with a decision of another DCA, or is certified by a DCA on a question to pass on a question of great public importance, or to be in direct conflict with the decision of another DCA. They have exclusive jurisdiction to regulate the admission of persons admitted to the Florida bar and to discipline those persons. They are paid $162,000 a year. So that's the basic structure of the judicial branch. And I was going to go into next the roles of public defenders and state attorneys and the attorney general, if you guys are ready to move on.
Here, real quick.
Yeah.
Do the justices have judicial boundaries in which they have to live?
The Florida Supreme Court justices, no, they just have to be residents of the state. Because their boundary is the state.
So they don't have to come from a specific area?
Their nomination.
Oh, their nomination. I'm
Right.
sorry. Go ahead.
Yeah. At the time of nomination, there has to be at least one justice from each of the 5 DCAs. So that if someone, for instance, Justice Perry is about to go off the bench here at the end of this month, and because he was the only justice that originally had come from the 5th DCA, then his replacement has to come from the 5th DCA.
So in essence, you would have at least 5 that come from certain boundaries, and then the other 2 would be picked at large?
Right, but they don't stay as an at-large seat because it depends on who leaves first. So it's written to say not that they have,
I got you.
that there's 2 at-larges.
In essence, it's possible for 2 or 3 to come from the same, well, at least 2 could come from the same.
There could be 3,
DCA, 2 or
mathematically,
3.
there could be 3 from a single DCA.
And then once they're appointed,
But once they're appointed, they live in Tallahassee.
And they conduct, their sessions are year-round? The court is in session year-round?
Yes. They do take, which month do they take off? They do take a month or so off, which is typical of most appellate courts.
Okay, thank you.
we
I had
used to
one-
have a term of court, but
I have one quick follow-up
eliminated that.
question. Was the salary for each of the judges at all levels of the judicial branch set forward by the GAA?
yes.
Okay.
A question about the size of the Supreme Court. Is that determined by the Constitution? Is that number set, or is that determined by statute?
That's set in the Constitution.
It's in the Constitution.
Because I imagine the number would be different if it weren't set in the Constitution. Okay. The Sixth Amendment of the United States Constitution protects the right to an attorney for those accused of a crime. The United States Supreme Court has interpreted that right to mean that the court must appoint an attorney to represent a criminal defendant who cannot afford to hire one. The most significant decision on this issue is actually a Florida case called Gideon v. Wainwright, in which the court held that the right of a poor person in a criminal trial to have assistance of counsel is a fundamental right and essential to a fair trial. In response to the U.S. Supreme Court case in Gideon, the Florida legislature established the public defender system in 1963 and required the establishment of an office of the public defender in each of the 20 judicial circuits. In order to be a public defender, you have to have been a member of the Florida bar for the preceding 5 years and be an elector of the state and reside within the territorial jurisdiction of the area in which you wish to serve. The public defenders are elected at a general election for a term of 4 years. Were you raising your hand?
No.
Oh, okay. I was like, oh my God, you have questions too? You have to answer it yourself. Attorneys from the Public Defender's Office can only represent indigent clients, adults and children, who were charged with criminal offenses, from felonies to misdemeanors, criminal traffic violations, juvenile delinquency, and criminal contempt. Or people held under the Baker Act or the Sexually Violent Predator Act. Defendants have to apply for and qualify for public defender assistance. Defendants whose income is at or below 250% of the federal poverty level qualify. Also, those who are unable to pay for the services of a private attorney because it will result in a substantial hardship on their family would be eligible. An attorney from the Public Defender's Office cannot represent any person, though, until a clerk or a judge makes the appointment. There is an application fee of $50, and if the person enters a plea or is convicted at trial, the court will enter an order requiring payment of reasonable attorney's fees, or the court can make the fee a lien. The fee is not ordered if a case is dismissed or a person is acquitted. Article 5 of the Constitution, and, I'm
Sorry to interrupt, one quick question.
Yeah.
Has that fee been tested constitutionally? I mean, is that
I am not aware of a
Curious.
test.
Okay,
It's really low.
yeah.
I was surprised to see when I did the calculations, and I actually didn't bring it with me, I should have. I actually calculated what's 250% of the federal poverty level, and I was surprised at how high it is, actually. So $50, after seeing that, to me, didn't seem like it was too much of a burden. So Article 5 of the Constitution and Chapter 27, and along with other statutes, establish the authority of the state attorneys in the state. There is one state attorney for each of the 20 judicial circuits. The Constitution requires the election of state attorneys in each of the 20 circuits every 4 years. The state attorney is the chief prosecutor in each circuit and is charged with the responsibility of representing Florida, the state of Florida, in county and circuit courts. They have to be an elector of the state and reside in a territorial jurisdiction of the circuit. They have to have been a member of the Florida Bar for the past 5 years. They have to devote full time to their duties as prosecutor and may not engage in the private practice of law. They're authorized to employ assistant state attorneys, and statewide there are about 1,700 of them. 20 state attorneys, 1,700 assistant state attorneys. They have some jurisdiction over civil cases as well as criminal cases. The civil cases are, for example, involuntary commitment of sexual predators, bond validation proceedings, consumer issues, and some environmental laws. The overwhelming majority of cases tried by the state attorneys, though, are criminal. The Attorney General is the statewide elected official responsible for representing the state as its chief legal officer. The Attorney General protects Florida consumers from various types of fraud and enforces the state's antitrust laws. The Attorney General also represents the state in cases of Medicaid fraud, defends the state in civil litigation cases, and represents the people of Florida in appeals of criminal convictions in state and federal court. Within the Office of the Attorney General is the statewide prosecutor's office that targets widespread criminal activities throughout Florida, including fraud, drug trafficking, and gang activity. So that's about it in terms of the basic structure and the players in the judicial system. I didn't cover private attorneys in terms of defense attorneys or civil litigation attorneys, but be happy to try to answer any questions you have on those issues.
There is someone in my district called the Regional Counsel, and I think that has something to do with conflicts in public defenders. Is that an appointed? Is that an elected? Tell me about that.
At one time, what is very typical in criminal enterprises is that often there's more than one person who's involved in a conspiracy to commit a criminal offense. At one time, the public defender can only represent one of the people involved in a criminal case. There'd be a conflict of interest to represent more than one. So at one point, the state had was employing private attorneys for the second, third, fourth, fifth co-defendants, and so on down the road. It became an expensive proposition to the state, and so, and I don't have the year. I apologize, I don't have the year. It was in the 2000s that the Office of Criminal Conflict was created. They represent the number. I guess the best way to say is that the second person involved in the criminal conspiracy where there's a conflict. These are statewide officers, there are 5 offices of them. They are on the DCA jurisdiction, so the 3rd DCA has a 3rd group, third conflict list. The Office of Criminal Conflict, I apologize, their name is really long and difficult to say. They also are providing state representation to a number of other places where the Constitution requires state payment of lawyers on behalf of indigent persons, for instance, in termination of parental rights and some other civil cases. Again, they only get number 2 down the road in the conspiracy, so numbers 3, 4, and 5, and et cetera, then would be private counsel that are paid for through other state mechanisms.
Did you just say that they would represent number 2 and then 3, 4, and 5 would be private counsel?
They're private counsel, right, or 6 or 7 or however
Yeah.
many are involved in the conspiracy, yeah.
Is that it?
Did that answer your question?
Yes, it did.
Okay, excellent.
All right, so you guys have my card, or you know where to find us, 4th floor, right around the corner.
Does this committee typically have jurisdiction over issues related to administrative law? Do those type of bills get, no? Okay.
No.
We don't know exactly, I just don't remember what the new jurisdictions are. When you guys received an email about which subcommittees you wanted to, check, try out for, they had the little jurisdiction paragraph. It would be on that. It's usually in the government operations area or in the rules and regulations subcommittee the last 2 years, but we don't have that committee anymore. So I'm guessing it's under Chair Caldwell's jurisdiction. Anything else? That's the one thing Nathan doesn't do, administrative law. Anyway, thank you so much.
Is there anything?
Hope you guys have a good afternoon.